I'm Dru Stevenson. This is for my administrative law class. And here I'm going to be talking about regulatory agency inspections. In other words, the body of law that governs when and how agencies can do on-site inspections, let's say of facilities or plants that are under their regulatory purview. So let's dive in. Many administrative agencies physically inspect the premises of regulated locations to monitor compliance with regulatory requirements. Statutory authorizations for such inspections are common in areas that are focused on public health or collecting revenue. One of the most pervasive government inspection programs is for meat and poultry industries. We basically have on-site federal inspectors all the time who supervise the slaughtering and packing operations from start to finish, day after day. So on-site inspections and visits are also a regular part of enforcing pollution controls, housing ordinances, and health codes and fire codes. It's a somewhat different matter if we have inspections of people's private residences. Government intrusions into private homes or apartments, regardless of the reason, uh, tend to raise constitutional issues. So let's talk about one of our leading cases about how the Fourth Amendment warrant requirement applies to administrative agency exceptions. And one of the biggest cases in this area is Camara versus Municipal Court. This is from 1967 from the U.S. Supreme Court. And here the court overturned convictions for people who refused to allow the police or inspectors to come in without a warrant, even though there was a municipal ordinance that authorized these inspections of the apartments. In Camara versus Municipal Court, even though the court ended up saying that some kind of warrant is required, especially in the home setting, an administrative warrant doesn't require a full showing of probable cause or individualized probable cause that is required to sustain a warrant in ordinary police work. Remember that ordinarily in criminal procedure or regular law enforcement work, officials, law enforcement officers who want to get a search warrant will have to show probable cause individualized for that person and premises, and that they expect to turn up some sort of useful evidence that's relevant to their investigation. It'll have to be signed off by a magistrate or a judge. The court said that it's a different area of law for administrative warrants and assessing the reasonableness of getting a warrant, let's say, for municipal code inspections of apartments. And so it's a lower threshold than we would have in the typical Fourth Amendment law for criminal procedure. So for building code inspections, for example, the court said that probable cause to issue a warrant actually exists for inspections if, quote, reasonable legislative or administrative standards for conducting an area inspection are satisfied with respect to a particular dwelling. The Supreme Court indicated that an administrative warrant merely requires some reasonable general criteria by which the agency decides when to conduct an inspection and showing that the agency actually followed its own criteria. In the casebook that I use for my course, the casebook authors also give an example explaining sort of the legacy of the case. Hypothetically, say there's an agency that inspects food processing plants for health safety. So if they decide that it's reasonable to inspect plants a certain number of times per year based on the plant size or plant output, then all they would need to show to get a warrant is the size of the plant and how long it's been since they did their last inspection. Another important case in this area of agency inspections is Marshall v. Barlow's Inc. In the casebook I use for my course, there's lengthy excerpts from this case that run for several pages. This is a 1978 case from the U.S. Supreme Court about OSHA inspections. And the question was about an OSHA inspection of a business without a warrant. And the court held that in this particular case, under these facts, that OSHA had violated the Fourth Amendment. This was a surprise inspection. So if entry to a surprise inspector is refused, the court said an ex parte warrant could still be obtained that would facilitate the inspector's reappearance at the premises without further notice. In other words, you can turn someone away who is there to inspect your facility or your plant or your store, but they're probably going to go and get their administrative warrant or what they need and come back. It's most businesses that are regulated just consent to the inspections. Marshall v. Barlow's clarified or reemphasized that to get an administrative warrant, an agency does not need to show probable cause that violations are actually occurring, but merely that a reasonable legislative or administrative standard for conducting inspections on a certain schedule have been satisfied and with respect to that premises. The court's treatment of probable cause here not really being necessary seemed to take away much of the protection that the warrant requirement in a criminal case. In Marshall v. Barlow's, the court expressly approved the idea that, quote, reasonable legislative or administrative standards governing warrants might involve nothing more than the desired frequency of searches of a particular area. So let's talk about the issue of consent or consenting to a search. The majority in Marshall v. Barlow's decided that the imposition of a warrant requirement on OSHA would usually not hamper the agency's effectiveness. In other words, the majority thought that most businesses would simply consent to searches. It would be the exception, not the rule, that they would have to get a warrant. The agency had claimed that they wouldn't be able to do inspections or enforce their regulations if they had to get a warrant every time. And basically, the majority didn't think they would need to get a warrant every time. Consent can be a significant factor, especially because federal courts have not really insisted on an especially clear showing of voluntariness to sustain administrative searches. For example, there's no right to be informed of your right to a warrant or your right to refuse access. So because of that, a lot of people are probably just going to consent. And that concludes our brief overview or introduction to agency inspections.